Okay, good afternoon everyone. Welcome to the first of our latest three-part webinar series on construction contracts. Our webinars will provide you with an understanding of three issues of critical importance in the construction industry, namely contracting for certainty, enforcing rights and limiting liability. Today's webinar will focus on the first of these, that's contracting for certainty, looking at the importance of getting a construction contract right from the outset. Now, before we begin, there's a few housekeeping matters to address. To minimise background noise, I have placed you all on mute. Could some of you are presently not on mute from your end, so could you please ensure that you press the mute button to avoid noise coming on to this webinar through your own system. If you'd like to ask questions, please do so using the webinar chat function. And in order to keep within the 30 minutes, we will answer as many questions as we can at the end of the presentation, time allowing, rather than as we go along. So I'm Iain Drummond, a partner in the Construction Disputes team, specialising in construction and engineering dispute resolution based in Edinburgh, and I'm joined this afternoon by Miranda Cannibal, a solicitor in my team. We regularly advise on transactional issues and dispute resolution matters in construction across a wide range of projects and clients, including private and public sector clients, contractors, consultants and funders. So we therefore have a great deal of experience working with unclear contract terms, with disputes on those terms, and in resolving such disputes through the courts, through adjudications or other dispute resolution processes. We also have an up-to-date understanding of the constantly evolving judicial approach to interpreting contracts. So our experience helps us to form the basis of the advice that we give to clients and of the information we will be sharing with you today. I'll now pass you on to Miranda, who will run through today's agenda.
Thanks, Iain. As Iain says, today we are focusing on contracting for certainty. We will start by looking at the most important aspects of construction contracts that parties ought to get right from the outset, largely because these are the most common aspects that parties later disagree on. We will then move on to consider some examples of poorly constructed clauses and how they can be improved. In the second half of our webinar, we will discuss two case examples of disputes arising due to contractual uncertainty, covering different types of clauses and the negative impact uncertainty can have. Finally, we will look at the practical implications of each case and what we can learn from them going forward. So let's start with the foundations of a construction contract and look at why it is so important to get these contracts right at the outset. A construction contract, in its most basic form, sets out the rights, expectations, risks, and obligations of the parties commencing a construction project. It is intended to reduce any uncertainty surrounding a project by clearly defining the parties' agreement and expectations and enables these parties to effectively plan for the future. As such, these contracts must be drafted carefully and executed in accordance with legal requirements for signing. For example, contracts must generally be signed by the parties and at least one witness, or by two directors in the case of a company. These signatures are essential for binding the parties to the terms that they have agreed. The following types of contractual provisions are the most important aspects for parties to get right from the beginning, as they are the source of most construction project disputes. Firstly, what works are to be done, and what is to happen if the scope of the work changes during the course of the project. When the works are to be completed by, and what happens if they are not. When payments are due, how they are calculated, and what happens if there are defaults in the payments. And finally, what happens if the works are not completed to the agreed standard. Linked to all of these aspects is the allocation of risk, which party assumes the risk of particular future events occurring, such as defects in the design or a delay in the works. We will be looking at this in more detail and at the risk of a delay in works in our first case below. The key point to note at this stage is that all risks must be considered and properly allocated to the parties. One of the more common reasons for uncertainty in construction contracts is the use of overly complex legalese and unnecessarily wordy clauses. Take this example by Mark Cohen in his article, How to Draft a Bad Contract. His example says, this agreement, along with any exhibits, appendices, addenda, schedules, and amendments hereto, encompasses the entire agreement of the parties and supersedes all previous understanding and agreements between the parties, whether oral or written. These parties hereby acknowledge and represent, by affixing their hands and seals hereto, that said parties have not relied on any representation, assertion, guarantee, warranty, collateral contract, or other assurance, except those set out in this agreement, made by or on behalf of any party or any other person or entity whatsoever prior to the execution of this agreement, and so on for another 81 words. This clause, consisting of, as you can clearly see, 174 unnecessary words, can be condensed into a mere 24. For instance, this agreement sets forth the complete agreement of the parties. There are no promises or representations other than those set forth in this agreement. When contracts are drafted carefully and concisely, they will serve their purpose of setting into writing the clear rights, obligations, and risks of parties that they have agreed to. The whole objective of contracts is to remove disputes on this. However, poor drafting can, in contrast, cause disputes. All of the terms should be certain. They must be agreed between the parties with their full intention to be bound by them. Then this is confirmed by their signatures. Disputes often arise if these provisions are not properly understood and agreed by both parties, despite the contract having been signed by them both. A signature on a contract does not always signify a full understanding and agreement. The main issue with this is that the disagreement or misunderstanding will generally only come to light when the relevant provision is tested and needs to be enforced due to an event occurring, such as delay in the works. Hence why it is so important to achieve complete certainty from the outset before it's too late. Drafting complex contracts in a clear and concise manner is challenging and requires skill and experience. The English language is generally imprecise, so achieving clarity is no easy task. However, when a contract is agreed and signed, the courts will enforce the terms of that contract.
In order to highlight the points just discussed by Miranda, we'll now turn to our first case, which is the case of North Midland Building Limited against Sidon Homes Limited, which is a recent case in which the parties' expressly agreed terms were found to take precedence over a common law principle known as the prevention principle, which we'll look at in just a moment. Now, in this case, Sidon Homes Limited employed a contractor, North Midland Building Limited, to design and build a large house in the Midlands under a JCT design and build construction contract. The parties agreed certain bespoke amendments to the standard form contract, and one of these was a clause concerning the way in which extensions of time would be dealt with. This clause became the focus of this case when the works were delayed and the contractor applied for an extension of time. The clause stated that, in considering an extension of time, quotes, any delay caused by a relevant event which is concurrent with another delay for which the contractor is responsible shall not be taken into account, end quotes. Now, a concurrent delay is a delay period which occurs because of more than one separate but concurrent event. In other words, one that is the fault of the contractor and one that is the fault of the employer. The delay in this case was a concurrent delay because a delay which the contractor was responsible for arose concurrently with a delay which was the fault of Sidon Homes, the employer. But in the clause that we've just cited, the contract states that the concurrent delay would not be taken into account and that Sidon Homes would therefore be entitled to levy liquidated damages for the period of delay. The question asked in court, however, was whether this delay, notwithstanding the presence of this clause, entitled the contractor to an extension to the contractual completion date. Sidon Homes, unsurprisingly, maintained that the contract provided a straightforward answer to this question. One only needed to read the clause exactly as it was written, such that the contractor was not entitled to extension of time in a concurrent delay situation. However, the contractor, although agreeing that the language of the clause was clear, sought to strike down the clause by reference to a common law principle known as the prevention principle. Now, this is a general common law principle whereby one party is not able to enforce a contractual obligation against the other, where that first party has prevented the other from complying with its obligation. Therefore, in this situation, the contractor argued the employer had prevented it from completing the works in time, and the employer could not therefore rely on the clause that denied an extension of time in the concurrent delay situation. Now, just pausing there, the majority of construction contracts do not have express provision for concurrent delay, unlike in this case. This is generally because prior to this case, there has always been some uncertainty as to whether or not such a provision would be enforceable in light of the prevention principle. Therefore, the two parties in this case were faced with a clear conflict between the amended clause that they had agreed at the outset and a common law principle. In the end, the Court of Appeal held that the express contractual term trumped the prevention principle at common law. The Court explained that the extension of time provisions in the standard JCT contracts have been previously interpreted to benefit the contractor in cases of concurrent delay. However, in this case, the amended clause agreed by the parties at the outset did not permit the contractor to an extension of time, even where the employer was partly at fault in respect that it had prevented the contractor completing the works on time. Therefore, the parties had expressly agreed terms in relation to extension of time in a concurrent delay situation, and the court held they were bound by this. Now, a number of important points can be taken from this case. Firstly, the case established that provisions allocating concurrency risk and delay are enforceable. Secondly, clear and unambiguous terms of contract agreed at the outset carry significant weight and will usually override common law principles. So, it is important to be careful when agreeing to such clauses that it is understood what they mean because the courts will generally enforce them, and they are useful in giving clarity to situations, as in this case, where concurrent delay takes place.
We will now move on to another case in which parties were bound by their expressly agreed terms, despite their later actions conflicting with what they had initially agreed. In the recent case of Rock Advertising against MWB Business Exchange Centres, decided in May this year, Rock Advertising entered into a license with MWB Business Exchange Centres to occupy office space for a fixed term of 12 months. The license contained a clause expressly agreed by the parties, known as a no oral modification clause. This is a standard clause which states that any variation to the contract must be set out in formal writing and signed on behalf of both parties in order to be valid and have effect. In other words, a variation to any of the terms of the license could not in this case be agreed verbally. By agreeing to such a clause, the parties are legally binding themselves to this process, by which they will later be able to vary the contract. In his judgment, Lord Sumption provides a useful summary of the three main purposes of including a no oral modification clause, all of which relate to achieving certainty from the outset. The first is to prevent abuse that could occur if written agreements can be amended by informal means. The second is to avoid disputes and misunderstanding over the precise terms of an oral variation, and the third is to allow corporations to police internal rules restricting authority to agree to variations. The issue in this case arose when Rock fell into payment arrears of over £12,000, and Rock's director proposed a revised payment schedule to a credit controller employed by MWB. He proposed that part of the upcoming payments would be deferred and the arrears would be spread over the remainder of the license term. Rock claimed that MWB had orally agreed to vary the license as per the revised payment schedule, whereas MWB considered the schedule only a proposal which was rejected. MWB then locked Rock out of the premises and terminated the license, and then sued Rock for the arrears. As Rock was under the impression the revised payment schedule had been agreed orally, they counterclaimed for wrongful exclusion from the premises. The question for the court to decide was whether or not the oral agreement between Rock's director and MWB's credit controller to vary the payment schedule was effective, despite the fact it did not comply with the no oral modification clause that both parties had expressly agreed to. The case was appealed to the Supreme Court, and the 5 judges who heard the appeal unanimously agreed that the no oral modification clause must be observed, thereby invalidating any oral agreement to vary the payment schedule. The court held that even when parties agree an oral variation in spite of a no oral modification clause, that does not necessarily mean they intended to dispense with the clause or that oral variations are forbidden. Instead, the court held that any oral variation would simply be invalid, and so the natural inference from the parties' failure to observe the formal requirements of a no oral modification clause is not that they intended to dispense with it, but that they overlooked it. The court then went on to say that if, on the other hand, they had the no oral modification clause in mind, then they were courting invalidity with their eyes open. The court therefore took the view that the parties were bound by the no oral modification clause, giving weight to their intention to validly bind themselves as to how future changes in their legal relations were to be achieved. The decision undoubtedly has practical implications for the drafting and agreeing of contracts. Most importantly, the clause confirmed that no oral modification clauses are effective. The inclusion of such a clause is a means of providing more certainty for contracting parties when expressly agreeing to contractual terms, as these terms cannot later be varied informally by oral means. Therefore, for large and complex construction contracts, it is worth considering including this clause in order to achieve more certainty.
Another example of courts giving primacy to expressly agreed contractual terms is the question of the application of good faith, which has been argued for some time now. Construction contracts sometimes contain a termination for convenience clause, which allows a party to terminate a contract without cause, in other words, regardless of whether or not there has been a breach of contract. There has been an argument for some time that this right should be subject to a common law principle of good faith, such a principle which is commonly applied throughout European legal systems. However, the EU courts have held that they are unwilling to dilute contractual termination clauses by reference to good faith. For example, in the case of MSC Mediterranean Shipping in 2016, Lord Justice Moore-Bick stated, "The recognition of a general duty of good faith would be a significant step in the development of our law of contract with potentially far-reaching consequences, and I do not think it is necessary or desirable to resort to it in order to decide the outcome of the present case." That case was one in which there was a contractual clause allowing termination for convenience, and the court decided that that right would not be diluted by reference to any duty or principle of good faith. The court's approach here ties in with the principle of freedom of contract, which is the idea that parties can enter into contracts without undue restrictions on or interference from government or from the courts. The courts will generally uphold this principle, for example, when interpreting contracts, giving the words used their ordinary meaning, and this is even where this leads to an adverse result for one party. So in other words, the courts say, we will uphold parties' freedom to contract and enforce their contracts as expressed by them. But the other side to that coin is that where interpreting the words that the parties have chosen to use leads to an adverse result for one party, that result will nevertheless be enforced. Similarly is the position regarding liquidated damages. Most construction contracts have a liquidated damages clause, which is a provision requiring a party in breach to pay a pre-agreed amount to the other party as compensation for that breach, such as in the case of delay to performance. There has been a public policy debate in the courts for many years as to the extent to which these clauses can or should be struck down as a penalty if they are argued successfully to be excessive. This public policy has been continuously narrowed over the years as there has been a growing reluctance by the courts to intervene in commercial contracts to declare particularly expressly agreed liquidated damages provisions to be a penalty. The public policy basis for doing so was narrowed even further in the case of L. MacDaisy against Cavendish Square Holdings in 2013, where the court held the clauses taken in the context of the agreement as a whole are not genuine pre-estimates of loss. On the contrary, they are extravagant and unreasonable. That is not necessarily conclusive. A commercial justification may mean that a clause which is not a genuine pre-estimate is not penal. As such, in this case, a liquidated damages clause that was pre-agreed was enforced on the basis that it was commercially justified, and that was even despite the suggestion that the amount that had to be paid was excessive. The principle was the courts will hold the parties to their express agreement.
So what can we take away from today? Firstly, it is vital that all terms agreed in a construction contract are certain before the contract is signed. Parties must feel comfortable that they will be bound by the terms agreed if they later need to be relied upon. Without certainty and clarity in drafting, disputes can arise over what was agreed or what the intentions of the parties were when agreeing the terms. This can result in costly and lengthy disputes and litigation, and defeats the purpose of having a contract, which is to express parties' rights, obligations, and risks in a clear way that reduces disputes and is clearly enforceable. Secondly, it is worth noting that the common theme in the cases we have considered today is that the courts prefer to hold parties to the terms they expressly agreed, even when interpreting a contract, particularly when those terms are clear and unambiguous, even in the face of contrary common law principles. Therefore, parties' agreement from the outset carries significant weight throughout the term of the contract in determining the parties' intentions, and even after the project is completed. For example, in establishing where the risk lies for latent defects. Also, because the case of Rock against MWB Business Exchange Centres confirmed that a no oral modification clause can be effective, parties should seek to include these when dealing with large construction projects to ensure the provisions agreed are fixed and cannot then be varied by an oral agreement between site representatives, for example. Finally, we would stress the importance of taking the necessary time and care at the outset when agreeing contractual terms and ensuring the contract terms are clear, unambiguous, and free from legal jargon to ensure there is absolute certainty as to what is being agreed. The contract is there for the benefit of the parties, to help deal with future risks and unknowns, and to give the parties security and hopefully more certainty before commencing a construction project. We have now come to the end of the presentation, which we hope has been useful and interesting, and we still have a few minutes to answer any questions. If you haven't already done so, please type your questions into the chat box now. Whilst you're doing that, I would like to take this opportunity to remind you of the details of the next two webinars in this series. On Tuesday, 30th of October, we will be considering enforcing contractual rights in more detail. And then on Tuesday, 27th of November, we will be looking at limiting liability in a contract. Both webinars will start at 1 p.m, and if you haven't already signed up to these, then please do so by visiting the News and Events section of our website. This webinar has been recorded and will be available on our Vimeo site shortly. So if you know of any colleagues who haven't been able to participate today, or if you think that it will be useful to anyone, then please let them know. We will be circulating details of the recording to participants after the webinar. Finally, we have our construction and infrastructure autumn breakfast seminars next week, on Tuesday 2nd of August in our Glasgow offices and Thursday 4th of October in our Edinburgh offices. Both seminars start with networking at 8 a.m. and presentations from 9 a.m. Our theme for these seminars is health and safety requirements, sanctions, and a general case update. We would be delighted if you were able to join us, so if you haven't already signed up to these, then please do so by visiting the news and events section of our website. We look forward to seeing some of you next week.
Okay, now we just have a couple of minutes for questions if anyone has any before we wrap up. There is a question somebody's asked about whether contracts can be signed separately, or whether contracts have to be signed by everyone at the same time in the same room. It is actually possible to sign contracts in what's called in counterpart in Scotland, and that was a fairly recent change. But that's been the position in England and Wales for some time now. So what that means is that parties can sign different contracts, or rather the same contract in different parts. And that will be a valid signature by law. Now, that's simplifying the position slightly, but it means that, for example, where there are international parties signing contracts under Scots law or English and Welsh law, those don't need to be done at the same time in the same place. So it's intended to make things easier for particularly international transactions and parties signing contracts in those circumstances. That might be something we consider covering in a future webinar, because there are some complexities around that, but the general principle is it can be done. Okay, I think that's all the questions that we have. So thanks very much for joining us, and we look forward to you dialing in hopefully to our next webinars. But again, thanks for your time, and we'll now end the webinar. Thank you.